All right, we want to welcome everybody to the Nassau-Suffolk School Board Association's webinar. And we also want to thank the team from Bond, Shonik, and King for taking the time out this evening to present some important information to you. I'm the Executive Director for the Nassau-Suffolk School Board Association, Bob Vecchio, thanking you all for signing up and joining us. I know we had a lot of people register who will be seeing this video on demand as well. We will be sending a copy of this recording along with the PowerPoint slides to your district clerks by Friday. And this video will also be available for on-demand viewing at a later date on our YouTube channel. The Q&A dialog box is open and available for you to post questions during the course of the webinar, and we will try to ask those questions of our panelists as they are going through the presentation. The purpose of tonight's webinar was put together so that you, as governance teams of your school district, understand the legal structure and setup of public education in New York. We have been fielding several questions about who does the commissioner report to, how much authority does SED have over local districts, who does the Board of Regents report to, and where does the legislature play their role. So that's why we put this webinar together, to answer those questions without offering opinions, but just to explain to you from a legal basis that structure. And the team that we have assembled here, I've been honored to work with and have known Mr. Howard Miller for, well, over 2 decades now. And he is a very talented educational lawyer. And his team, as well as the firm of Bond, Shonik, and King, they have offices throughout New York State. They are a rather large firm that one of the things that they do very well is education law, and we want to thank the team for taking the time out of putting this material together for us tonight, and more importantly, taking time out of their busy schedules to present to you this information so that we help inform our governance teams about the legal structure of New York State. So without any further ado, I want to introduce Mr. Howard Miller, who, again, a really good guy. I've known him for a long time, and he is one bad lawyer, because I will tell you, he just earned a black belt in jiu-jitsu, so you don't want to mess with him in court or on the streets. Congratulations to that accomplishment, Howard. And even though we can question your judgment about being a Viking fan, we welcome you to the program, and I turn it over to you, sir.
Okay, so just one comment about Brazilian Jiu-Jitsu. Unfortunately, we cannot use that on our friends in Albany to submit them if we want to do. If that were the case, if we really could, then I suppose instead of being on this webinar, all of you would be at your local martial arts school. In terms of my being a Viking fan, that's true, and it shows some mental health issues on my part. For those of you who do not know, the Vikings have been in 4 Super Bowls and managed to lose all 4 of them. And every year at the beginning of the season, as I put on my Minnesota Vikings paraphernalia, my wife tells me that watching me root for the Minnesota Vikings is like watching Linus in the Pumpkin Patch. It's just never going to happen for me. So one disclaimer before we get going. Ordinarily, I would be doing this webinar from my desk at work. For various reasons, I have to do this at home, which means that there is a very real chance that my 6-month-old golden retriever puppy, Katie, might want to chime into our discussion. And I feel compelled to note from the outset that any views Katie expresses are her own. They do not reflect the philosophies of Bond, Shonik, and King. And as you can imagine, Katie does not believe that there ought to be regulation of any kind over her activities, and believes fully that she ought to have local control over the kitchen and all of its content. So we have that ongoing battle with her. I've been representing school districts now for over 30 years, and I find that we're at a unique crossroads. We find ourselves feeling overregulated but underfunded. We have to prepare students to enter a global economy at a time when there's lots of political divisiveness, when children and staff are suffering from mental health issues, board members too. And I know some of you feel that board member mental health is somewhat of an oxymoron, but we are concerned that we are seeing a flight of really good educators and board members who have decided that they just didn't sign on to being a punching bag. So we are trying to do right by children while navigating all of our regulations. So if Bob, if you could go to the next slide. So why are we here? I suppose in the literal sense, I am here because after I graduated college, I wound up working for an investment firm. And at a time when I was contemplating leaving Wall Street and going to law school, my friends and family failed to rise to the occasion and hold an intervention to make sure I was of sound mind and body in making that decision. In a similar vein, you were all here because when you decided to volunteer to run for school board, your friends and family failed to do an intervention to make sure you were sound mind and body before you entered that arena. But the real reason you are here is because you care about kids and you want to do right by them and give them every opportunity to reach their outermost potential. And as we see from the second quote, you have to do that while being regulated. And you have people who are in charge of the system that governs you. And it sometimes feel that they're not necessarily consulting with people who are on the front lines of education in making their regulations. And that can be awful frustrating. And what the Commissioner of Education has over us is that Commissioner has been delegated awesome power by the state legislature. And part of that power resides in Section 306 of the Education Law, which we'll talk about a little bit later. But that power allows the commissioner to remove board members and also to withhold state aid when the commissioner feels that a district is not complying with a decision of the commissioner or regulation or law. That being said, that does not mean that you are hamstrung entirely in terms of advocacy. And we're going to talk about a little bit later how the structure of our system works, the power of the commissioner, the power of BOCES. What is guidance versus law? When is guidance just guidance that we don't necessarily have to comply with? When should we not comply with certain guidance from the state education department? And we'll talk about how to advocate without necessarily risking penalties from the commissioner. And with that, I will turn it over to Candace.
Howard, I think that Candace is having some technical difficulties. Did she manage to get back logged on?
Okay.
I believe I am on now. Can you hear me all right?
We can hear you.
Okay, that's great. Thank you so much, Howard and Kate. Glad to be with all of you today. I'm going to give a quick summary of the different types of school districts in New York State. And part of the reason that we're starting with this background is that as we're looking at the various laws that apply to school districts, it's really important for us to look at the type of law that is applicable to our particular type of school district. Some people think that the New York State education law is kind of one blanket law that applies equally and in the same manner to every school district, regardless of whether it's a union-free or a central or a city school district. And that's true in many cases, but not in all cases. So we want to be sure that we understand the different types of school districts and how they were formed is sometimes instructive in how we move forward. So common school districts are the oldest type of school districts. They were actually enacted in 1812 by the legislature, and they don't have the legal authority to operate a high school, but they do often use the high schools of a neighboring school district. That is where they send their children. As of 1998, there were 10 common school districts operating in the state, so certainly a very small number of districts. Next slide, please. Common school districts are governed by either a sole trustee or a board that's comprised of 3 members. Next slide, please. And now we move to a form of school district that's much more common, especially on Long Island. We have many, many union-free school districts. This came about in 1853, and the notion or the reason for these union-free school districts as it was originally conceived was to combine 2 or more common school districts, joining them to provide a high school. And many of the early union-free school districts had boundaries that were coterminous with the boundaries of a village or a city. It provides secondary education, as I said, but there are some union-free school districts that do not operate a high school. A small percentage, about 1/6 of those union-free school districts. Next slide, please. So we know that central school districts are one of the most common forms of school districts in the state right now. They came about in 1925. A big difference between central school districts and union-free school districts is the size of the board. A central school district may consist of 3, 7, or 9 members, and their terms are a bit different than what we may find in some union-free school districts. Next slide, please. City school districts applies to cities under 125,000 people in population, and then there are other city school districts that are over 125,000 in terms of population. Those are the big five, as we call them. Next slide, please. In those big five that we're talking about, the educational function is a part of the overall city government. So they operate a bit differently than districts that we have on Long Island, in which we have the Board of Education that is setting policy and basically making most of the rules for the district. But the Board of Education in some of these big five city school districts does have some influence and impact. Funding for the school system in those city school districts is part of the overall municipal budget. Next slide, please. Central high school districts, they're pretty unique. We only have about 3 of them, in Nassau County is where we'll find them. And ultimately, this is not a type of high school district that kind of took off in terms of being spread across New York State, but we certainly see very good work done by our current central high school districts that we find in Nassau. Next slide, please. And here I'll turn it over to Kate Reed to talk about BOCES. Thank you.
Thanks so much, Candace. So we wanted to give that coverage just about the structure of school districts in New York State, because that really is necessary to understand that, you know, a lot of these other topics regarding regionalization, consolidation of functions, and shared services really also intersect with the BOCES, right? So we also wanted to cover some of the basics of what are BOCES. How did these entities come to exist? They're very unique in New York State, these BOCES that exist. And then what the powers of the district superintendent are as they relate to issues such as the reformation of boundary lines for districts. So BOCES, as I said, are a very unique, unique special unicorn that we have here in New York State. They are independent municipal corporations by law. So very similar to each of your individual school districts as you're part of a government subdivision or subdivision of the state. The BOCES similarly is a contained municipal organization. They exist and were formed by the state legislature, and we're going to talk about how the legislature forms entities and other things. But just as the legislature formed the various types of school districts, one after the other, as Candace explained, the legislature also formed these BOCES to be essentially independent municipal organizations that consist of leadership from all of the component districts that make them up. And the whole concept of a BOCES is that when we share services regionally, we save money is supposed to be the concept. It doesn't always work that way, as we all know, and there's inefficiencies built into the systems at every level. But that's what the concept is, right? That when we share services among multiple districts that need those services, it results in a reduced cost and a more equitable economic and efficient use of both state and local resources. So I have a wonderful retired DS who I still work with regularly, who will go unnamed in this presentation. But one of the things she always says is that the things that make BOCES interesting, they don't have the 3 Bs that are in school districts. They don't have budgets. They don't have balls, so they don't have sports. They don't have to deal with athletics and athletic parents, which is, of course, one of the things that school board members are well versed in dealing with. And they don't have to deal with voters whatsoever, right? So as a result, they're a little bit different and they function a little bit more differently than other school districts. The geographic region that's covered by a BOCES is called a supervisory district. That's a term of art under the education law. And it consists of the component districts that are within that geographic region. So a question that we have received over the years sometimes is, we don't like our BOCES, but we like what the neighboring BOCES is doing. Can we join that BOCES instead? And you would think the answer would be yes, because if the whole concept here is economical and efficient operations, districts should have that option, right? Well, the law doesn't work that way. The education law says you are a member by law of the BOCES that corresponds with your geographic region. Now, what can you do if you don't like your BOCES? You don't have to opt into the services. Services are always optional. So the BOCES has a three-part budget essentially that is funded by the component districts. There is a programmatic portion, a capital portion, as well as an administrative portion. Even if you, as a district, do not participate in the administrative portion, or in the services portion rather, and purchase specific services, you're still required to pay your share of the capital portion and of the administrative portion. So as I said, BOCES are considered to be corporate bodies. All BOCES property is held for the benefit of the BOCES. BOCES can buy, sell, renovate property just like a school district. And currently, for your interest, those who are interested, there are currently 37 BOCES that are recognized under the education law. Next slide. So again, there's no authority your process by which you can terminate your status as a BOCES component. You can boycott the services, but you're still required to pay the share of your administrative costs. Once a district becomes a component district of the BOCES, that's what triggers its obligation to pay those capital and administrative costs. Then with respect to programs, you get a menu, and your administrators are well accustomed to dealing with this. Every spring, when BOCES budget season comes around, they will distribute a book of contracts that are available for shared services through that BOCES. And the school district has the option of opting in or opting out of whatever services it wants. It's essentially a menu, right? And then with the programs, you only pay for what you actually use according to whatever funding formula that BOCES has agreed to use. You've probably heard the word COSER kicked around. COSER is the acronym for Co-Services Agreement, and this is really the mechanism that drives the way BOCES operates. BOCES by law can only offer shared services. They cannot offer a service that's only available to a single school district. In order to have a BOCES service, you have to have a desire on the part of two or more districts to share a service, and there has to be a co-services agreement, or a COSER, which has been approved by the Commissioner of Education. There is a database of the COSERs that have been approved by State Ed. I like to call that the big book of BOCES COSERs. And it's just absolutely riveting reading. I encourage you all to peruse it, but it's fun to look at what State Ed has actually approved as shared services in New York State. And there's some interesting anomalies. So for instance, if you look at that big book of COSERs, you'll see the state education department ultimately decides what goes in that book and what stays out. And that is power granted to State Ed through Section 1950 of the Ed Law, which is the BOCES law. And for example, BOCES are authorized in New York State to offer labor relations services. So they can offer through a COSER that is aidable, in fact, it recovers aid, labor relations services to assist districts with managing employee relations and collective bargaining. However, the commissioner to date has refused to approve a COSER for legal services. Phew, for us, for job security, right? But essentially, you cannot offer legal services through a COSER. Why? Because the commissioner said so. It's not included in the big book of COSERs. So again, services go into that big book of COSERs if there is an established need that the component districts have demonstrated, and if there's two or more districts that are committed to sharing the service, because again, sharing is the essence of the BOCERs. Not all BOCES services will generate state aid. That is ultimately something that's determined by the commissioner in the big book of COSERs, indicates which services are aidable and which do not generate aid. So a great example of services that do not generate BOCES aid. When your district places a student with special education needs in a special education class at the BOCES, you may think you're going to get BOCES aid on that. You actually don't. Special ed services are exempted from BOCES aid, but they are eligible for higher special education higher cost aid. So there is an aid revenue source, but it's not the same as the other BOCES services. Next slide, please. So why do we enter into COSERs? There's lots of reasons, and they all go back to that economy and efficiency is really supposed to be the guiding considerations here. So typically what we see is that when COSERs come into existence, it's because there's a demonstrated need. In many parts of the state, we have many small districts that are very geographically diverse. So a school district, for example, may not have enough students to justify having a 12 to 1 to 4 self-contained classroom on their premises. But if they pool their resources with the other component districts, there may be enough need among all those components to justify that self-contained class. Other situations, maybe it's specialized, right? That it doesn't make sense for individual districts to buy that equipment for students or for certain programs, vocational programs, career and technical programs, etc. Most districts in the state outsource a significant portion of their career and technical education to the BOCES already. That's one of the primary functions that they serve. So again, BOCES in some instances, because they're dealing with a higher volume and they have representation of multiple districts, can then pool those resources in order to provide better and more economical opportunities. So again, the Big Book of COSERS is available at the link in our slides, and we encourage you to peruse that at your convenience. Next slide, please.
And before we go to the next slide, Kate, a question came in. Are there any districts on Long Island that we're aware of that is not a component district of one of the three BOCES?
Oh, that's a great question. So the Big Five, I should have covered that. Who's included in BOCES? The Big Five are exempted by law. So Rochester, Syracuse, Yonkers, New York City, Buffalo cannot participate in BOCES services, with a couple of little exceptions for Rochester. I am not aware of any districts in Long Island that do not belong to a BOCES. I believe there are 3 school districts statewide that are not currently affiliated with a BOCES. And my recollection is that none of those are in Long Island, Bob, but don't quote me on that. And I will ask Howard and Candace if they want to correct me on that too before I move on.
I'm not aware of that of one, but we can certainly look into that, and Bob will email you if we become aware of one.
Okay,
well,
thank
we'll
you.
double check that. My gut is not on Long Island, but we'll double check that and circulate the answer, Bob. This is just a fun chart that shows statewide the distribution of BOCES, how BOCES are utilized and the specific types of services. So you can see special ed is a huge piece here. As we know, special ed is a huge budget driver for school districts statewide, because those are mandated services that districts don't always have control over. So special ed takes up a huge component of this. Other administrative services are a big portion too. In smaller districts around the state, it is not uncommon that school districts will use a BOCES for a shared business official, for instance, or a shared treasurer, or a shared payroll clerk, a function that is required in a school district, but in a teeny tiny district, there's no need to have full-time FTE for that position, where it could be shared across multiple areas. Non-instructional and instructional support is a big component as well. Many of our BOCES belong to a RIC. The RICs were established by the commissioner and by the New York State Legislature to be able to enhance technology and instructional support services that are delivered to enhance professional development, essentially, for the staff of the districts. So that's a huge thing that districts around the state also rely on our BOCES for. Bob, did you have a follow-up?
And a RIC stands for Regional Information Center, for those
Thank
that
you. I'm sorry.
love acronyms.
We use the acronym SOUP, and I'm sorry about that. So if I ever use an acronym and speed past it, Bob, just cut me off. Thank you so much. Next slide, please. Who can participate in COSERS? Component districts, non-component districts. So this is known as the cross contract, and it's one of my favorite things to do when I have a district that can't find services within their existing BOCES. There is a law that says if your BOCES doesn't offer a service, you can get permission from that BOCES to enter into what's called a cross contract, which is essentially you piggyback the COSER that is being offered by a different BOCES. So any BOCES service that's available in any BOCES in the state is available to be piggybacked like this, as long as your district, your BOCES in particular, doesn't provide that service. That is a huge opportunity for shared services and economy that a lot of districts do not take enough advantage of. So even if you're not a component of a district, of a BOCES rather, if your home BOCES does not offer a particular service and the BOCES in another part of the state does, you can participate in that. So just by way of example, we represent Capital Region BOCES. They are a very entrepreneurial BOCES. They're kind of an industry leader in that regard. One of the contracts they offer. They have a COSER for hearing officer services for 3214 hearings. And that's something that they cross-contract with across the state because many BOCES do not offer that service. Districts outside, again, would have to go through the cross-contracting process if you're not part of the BOCES, but very easy and economical process. Non-public schools are authorized to use BOCES for some very, very limited functions of data processing and services. And charter schools likewise can use the BOCES for certain limited occupational education and data processing, so very limited use. Often we get questions from our BOCES clients about, can we make our services available to community colleges? Because again, they tend to be very entrepreneurial by trade. Can we offer these services to colleges, to universities, to credit unions, to other not-for-profit? And the answer is no. Really, the BOCES services are reserved for public school districts with the exception of these limited exceptions. Next slide. Let's talk about the role of the district superintendent. So we use the acronym DS. That is on purpose. So by law, the superintendent of a BOCES is not called a superintendent of schools. They're formally called a district superintendent, and that's because they preside over the supervisory district of the BOCES. So a DS has the authority under provision of the education law to actually create a new district out of territory that's not already part of a district, as long as that territory is within the parameters of the BOCES. That power has been exercised very, very seldomly in the past 75 years. Why is that? Because going back to Candace's portion at the beginning, state ed really did a consolidation effort at the turn of the century to consolidate a lot of the territories that had previously had to transport for student transportation. And as a result, there simply aren't very many territories in the state anymore that are not covered by a school district. So really, practically speaking, that provision is not utilized very frequently. There's another provision in 2218 of the ed law that is also pretty interesting. And what that says is that the DS can actually order the partitioning of property from an existing school district. They can dissolve or reform the boundaries of existing school districts, or they can form a new union for your city district out of existing territory. The proviso there, though, is they can't do that without your consent as a district. They can only do that if 2/3 of your school board or a majority of your qualified voters within each affected district actually votes to make that go forward. So in practice, this is not done frequently either. Typically, and we've, Howard and I actually advised a client up in closer to my part of the state last year about this. In practice, typically 2218 is not utilized unless there's a situation where both districts have a desire to consolidate and they both mutually approach the DS and say, what can we do and talk about this, right? Typically, if it's not initiated by the schools, that's not something that the DS is going to self-initiate in our experience. Why? Because it can't be done without the consent of the component districts involved. Next slide. Okay, Howard, do you want to jump into?
So where we want many, many years ago, some school districts on the North Shore of Long Island asked BOCES to help extend their boundaries into the Long Island Sound to capture some pipeline revenue. And I think we got cooperation from that, but otherwise it seems to be pretty rare to get involved in that.
That's a really great point. So sometimes that power, I'm aware of that too, Howard, that sometimes that power will be exercised in order to bring extra resources into the district from land that currently doesn't have residents. And again, that requires the consent and typically is initiated by the involved districts. Next slide, please. So with respect to the clarification of district boundaries, this is something that often comes up. Parents will often be annoyed that their home is zoned for a particular district. You've probably, as a school board member, received love letters from parents who are unhappy because they've bought a very expensive house that they thought was in your district, and that's the whole reason they bought the house. And then they're alarmed to learn after they move in that, oh, even though their post office has your town's name on it, they are not zoned for your district, right? They live in another district. So that's typically where we see these applications for the clarification of boundaries. There's several commissioners' appeals where parents actually went to the commissioner and said, this boundary has to be changed. Now, interestingly, the DS has the power to alter and clarify district boundaries. It's conferred by the education law. However, he or she cannot do it unilaterally. It has to be done with the written consent of all the districts who are involved. Conversely, the Commissioner of Education has the authority to override a lack of consent and do it herself. That's a power that's right in the education law, so therefore conferred on her by the legislature. And also, she can overrule if a school board rejects a petition to clarify a boundary. The commissioner can actually get involved in that as well and set that decision aside. So only the commissioner can be involved in consolidation, alteration of boundaries, or the creation of any new city school district or an enlarged city school district. The enlarged language is kind of an anachronism now, but essentially it means that you are a city district whose boundaries are not coterminous with the town or village or city that you are located within. So most of our city districts in New York State are considered to be enlarged because they encompass some of the surrounding areas as well. Basically, commissioner has full authority to define the boundaries of those districts. DSs cannot do anything with respect to city districts. Similar central districts, because the commissioner, going back to Candace's point, that was really the commissioner's initiative of centralization at the turn of the century. There are provisions in the ed law that say the commissioner must be involved if there's going to be the formation or change of any central school districts. Next slide, please. So I'm done with our BOCES stuff, and I think we're passing it back to Howard now to talk about the regulatory framework and powers of the Commissioner of Education and guidance versus regulations and all that fun stuff.
So I am going to thankfully punt to Rachel on this part of the presentation.
Thanks, Howard. Yes, hi, everyone. So I'm going to talk briefly about the role of the Commissioner and the Board of Regents. So we heard from Candace about the formation of school districts, and we heard from Kate about BOCES, that overseeing really all of New York State's education system is the Commissioner and the Board of Regents. So, as we all know, one way or another, the Commissioner specifically has powers to, general supervision over boards of education, enforcing the general and special laws of the education system, and executing educational policies determined by the Board of Regents. And as we heard from a little bit from Howard, Kate, and Candace, that can include a lot of things, including district boundaries and state aid and, a whole host of other issues that arise in the general school system. Next slide, please. So this is just a general chart giving an outlay of the overall governance of New York State. Next slide, please. So as we all know, you can file appeals to the commissioner. The commissioner has very broad powers to review general affairs of the school system. So like I mentioned, that includes suspensions, that can include budget questions, residency questions, election disputes, district boundary disputes, among other things. Next slide, please. So, and again, with the wide variety of appeals that the commissioner gets, he or she can issue a wide variety of remedies, except for the ones listed there. So they cannot issue a protective order. She cannot award monetary damages. She cannot order a school board or a school district employee to issue an apology. She cannot impose a reprimand or a fine, issue advisory opinions, or address novel constitutional issues, though we do sometimes see that the commissioner will issue his or her discretion as to what they believe policy or constitutional issues are. Next slide, please.
So a quick question to that point too, where you say the commissioner can't impose, or reprimand, a fine. There was some talk a while back with the mascot issue that they would withhold aid. Kind of distinguish between withholding aid and how they're not permitted to issue a reprimand or fine. How is that different?
So yeah, I have that memo from the state on the mascot right in front of me. So that power derives from 306 of the ed law, where they can withhold aid. I think this is more in terms of reprimanding or fining employees in that regard, that the commissioner has no power to do that. but Rachel can expand upon that if I got that wrong. But I know the memo you're talking about, and what the commissioner did in that case said there was decisional law on point, and said it basically to school districts, and this is the big anvil that they can hold over us, if you do not comply with that order of the commissioner, we can remove you or we can withhold your aid.
Okay,
And
thank you.
Howard, I think the other point there too is there were a series of appeals several years ago where board members and community members tried to get board members reprimanded and fined for various forms of alleged misconduct. And the commissioner issued decisions in that essentially saying, no, removal is the only remedy that is available to me if you have a board member that's not behaving themselves.
And that can be real frustrating because sometimes you don't have enough to get the board member removed. But you'd love for there to be at least a reprimand. Now, this gets into the weeds a little bit. The commissioner has upheld a kind of counseling resolution, which is not necessarily a reprimand, but the line between what is a resolution being critical of the judgment of a board member versus what is a formal reprimand gets very blurry. So that's something you would need to talk about with counsel. But we have had occasion to draft resolutions by a board where they, called out a board member for saying, let's say, inappropriate things, racist things, anti-Semitic things, or doing other conduct that is disruptive of the board's process itself and creating distrust among board members. So we have seen that.
So this is just an example of one way the commissioner can exercise her power. This was a case where the commissioner determined that the district had neglected the public school system in favor and really had passed a budget that favored the non-public school district. So this is a district that has a significant amount of students in non-public schools. And the commissioner came back and said that budget's not okay. You need to pass a budget that adopt a budget that calls for an additional 4.38% increase on the property tax levy. So next. Yeah. Sorry, Howard, go ahead.
Surprised to me, but there is a statute that specifically gives the commissioner that power. And because you would think, well, if the voters didn't approve it, how is the commissioner going to do that? But there is that power.
Next slide, please. So, I think we've all seen, the commissioner has broad powers. So they can review questions of discretion and policy, which is a little bit different than what courts can do. And they can substitute their judgment for that of the officer whose action they're reviewing, which is also something that we don't normally see from other forums. Next slide, please. And what the commissioner also oversees the New York State Education Department's Office of Counsel. So Office of Counsel provides legal counsel to the commissioner, and they also issue what we always refer to as guidance documents, right, or formal opinions of counsel. And that's supposed to help districts comply with existing law and existing policy that may or may not be clear to us. And I think we're going to talk a little bit more about the distinction between law and policy on the next few slides.
Okay, Bob, did someone raise their hand for a question?
No, I don't see any hands raised. So.
All right, thanks.
And again, if anybody has a question, post it in the Q&A dialogue box, and we'll ask our panelists.
So we're going to have a little round robin discussion here about, and this is a really tricky issue and has become a big source of questions from our clients. What's the difference between guidance and law? And it just, one thing just to bear in mind, we're going to give you the philosophy of Bond, Shannick, and King, and your individual counsel may have different philosophies on this, and particularly as applied to unique situations. So as a general matter, guidance documents are not legally binding, but that's kind of too simple of a thing to say. So They're not law, and there's some cases in the upcoming slides that we don't have to necessarily talk about in detail where a court has said, you know what, the guidance issued by the state education department was wrong, and we're not going to, as a court, we're not going to follow it, and we're going to apply the law. So, but there are some practical concerns. So when the state issues guidance, let's say on health and safety issues, and I'll use something, let's say peanut allergies, and says this is the protocol that ought to be used in the classroom. If a school district does not follow that protocol, and again, it's not law, but it's guidance, and something, God forbid, happens and a student, there's a tragic situation involving a student, and their parents were to bring a lawsuit against the school, what would happen is the court may say the guidance reflected the appropriate standard of care that the school district should have followed, and that the school district is liable for not following that standard of care. So that when it comes to health and safety issues, we're more inclined to advise clients to say, although it is not etched in the law books, it's something you ought to be following. Another consideration is what forum are we going to be having a fight in? So if the commissioner issues guidance and the forum we're going to be fighting is before the commissioner themselves, we might be tilting at windmills in terms of not complying with that, because in an appeal to the commissioner, we're going to lose. So where we've seen this come up, and I'll ask my colleagues to jump in on this. For example, there's been some guidance on just how long and how old we educate students with disabilities. How old? When is the cutoff for that? And if we choose not to follow guidance, where we would have to go to have that fight. So I don't know if one of you wants to take this up.
And while they're jumping at the opportunity to answer that, Howard, kind of an off-topic question, but again, just trying to address questions as they come in. Are public schools required to participate in the New York State retirement system? And if not, do you know of any?
Their staff are part of the New York State retirement system.
So they're New York State employees by set up, so they are required to participate in the pension system.
IRS. I'm not aware of an opt-out of that, and I don't know if Kate or Candace or Rachel are, but
I know there is for higher ed on the ERS side. There's some optional there, but for public school districts, I believe it was optional at one point, Bob, but that's no longer the case for any active employees in any public school district in New York State.
Thank you.
Mm-hmm. Okay. Candace, did you want to weigh in?
Yeah, just going back to your question about special education, just to set the stage for those who may not have been following this development in special ed. Recently, the commissioner and the Office of Counsel issued guidance regarding the education of students with disabilities beyond the age of 21, and their justification for having schools requiring schools to provide that education was based on a Connecticut case. So there's still litigation ongoing, but I think the point that you're trying to make, Howard, is when there is a situation in which the Office of Counsel, the commissioner's office, is saying school districts, you must do X, but we are saying, well, we don't see that in the law. Can you point us to the law that's requiring us to do that? Then where do we fall in terms of that no man's land? And I think often it will come down to a decision made by a district as to whether or not it's practical and it makes sense to kind of fight City Hall, so to speak, in terms of having that opposition with the commissioner's office.
And I think, Candace, you'd probably agree too that sometimes there is a closer connection, between the law and guidance versus other situations where there isn't. So I think this age 22 thing is a great example of that, in the sense that the Second Circuit case was very clear that under Connecticut statutory law, services are required until the day prior to the 22nd birthday. Now, New York State Education Department said the language that was interpreted in Connecticut is identical to the language in New York State, in our statute, right? And given that the Second Circuit Court of Appeals has jurisdiction over Connecticut and New York, we can hypothesize that the Second Circuit would reach the same conclusion. That is potentially a much more defensible position, I think, for the state to take, where I think many districts take issue or start to ask questions, is that the guidance went further than that. The guidance said, in addition to providing services until the day before the 22nd birthday, boy, it's awfully really nice if you'd also consider the services for the rest of that school year too, even though PS, we're not giving you any aid or support to do that, right? And I think that's the piece where we've really seen a lot of pushback from districts saying this is just, what is this suggestion or recommendation? Do we have to follow it? Is it binding? Well, in that particular instance, the answer is no, because the state itself, even in the guidance, says this is a suggestion or recommendation, not a mandate. But all to say, not all guidance is created equal. Some guidance is based on the application of precedent issued by a court or an agency that has jurisdiction, and that's more persuasive guidance, versus sometimes when the agency is going out and staking its own territory on things, it's harder to see the connection with the law.
And
Yeah.
somebody posed this question, and we may be jumping ahead, and if we are, just say we'll get to it. But the difference between commissioner regulations and education law, and must the regulation conform to the letter of the law, or does the commissioner have the ability to interpret the law and write a regulation which is broader?
So the commissioner, they have to be in harmony with one another, but the commissioner can't issue a regulation that actually conflicts with a legislative enactment. So if the legislature says that kids can be educated up until age 21, and the commissioner says you have to educate them up until age 25, that regulation is going to be struck down as invalid. That would be the commissioner overreaching and violating what is said in the statute. So the commissioner has some leeway in making a statute a little bit broader in how the commissioner interprets it, but it can't go so far as to actually contradict what the legislature said.
Okay, thank you.
So I think if we could advance a couple of slides, Bob, we're going to go one more and another one. Sorry, it's going to take me a little, another one. And if we can go here. So Kate is now litigating a case, and it has to do with the guidance issued by the New York State Education Department about transgender students and how we ought to accommodate transgender students. And part of that guidance is somewhat in legal no man's land and is being litigated in New York, and similar guidance is being litigated throughout the country. And sometimes where we have a situation where we're looking at things and we're trying to give our best estimate, well, what will happen if this case hits the highest court? And looking at the makeup of what our Supreme Court is like, how are we advising our clients? And what if state guidance conflicts with federal regulations? So I'll ask Kate to take this on, because it is.
Yeah, so I think this transgender issue is a very excellent example. Howard just made the observation that that our regulators cannot enact guidance or regulations, for that matter, that conflicts with statutes. Well, the other piece is they have to pass guidance and regulations that are consistent with both the state and federal constitution. So whenever the state issues guidance that is controversial, and I think no matter what your political beliefs are, we would probably all agree on this call that this is controversial guidance that the state issued regarding the accommodation of transgender students. And whenever an agency issues controversial guidance, there is always the risk that people who are opposed to that guidance are then going to have the argument that this violates, in addition to exceeding the commissioner's power, right, that it also violates some constitutional right that they have. So we anticipated this. I would say I'll pat Candace and Howard and I on the back. We saw this coming. Frankly, I love litigating cases, so I was thrilled that we got this lawsuit because it's fascinating. It's a lot more interesting than our, daily issues that we deal with. And lots of really great issues of first impression in it that we're going to make history deciding over the next few months. But to give a little bit of the lowdown there, what is at issue is that the state's guidance that they put out in June of 2023 states that if a student tells a staff member in a school that they are transgendered or transitioning and directs the staff member not to tell the parent, that the school district should abide by the wishes of the student. Now, many advocacy groups who are opposed to transgender rights, including the Alliance Defending Freedom, take a different position on that. They take the position that that is violative of parents' constitutional rights to control the upbringing of their children in school. And in fact, they have started lawsuits all over the country. And we're lucky enough to have one of them up here in the Northern District of New York that we're defending that involves that very question of, does the parent have rights in this situation? And that issue is currently, as Howard said, completely undecided. There is no answer to that question. So the unfortunate thing when you're operating in a school district in 2024 is that you're between a rock and a hard place in a lot of instances, because if you follow the guidance as written, you're potentially courting a claim from a parent. If you don't follow the guidance as written, you're potentially courting a claim from that, from that transgender student or gender nonconforming student or some advocacy group that picks up their cause. So I think this is a great illustration of whenever this controversial guidance is issued, it's always important to consult carefully with your legal counsel to do an individual assessment of your risk tolerance as a district and make sure you understand the risks on both sides, right, of complying versus not complying. What is the greater risk that you'd like to take? What are the potential ways to mitigate that risk? And I think this guidance is also reflective of the fact that, like in many situations, a lot of these very sensitive situations are very fact intensive. We want to look at each case on its own facts to help make sure that we're mitigating risk as much as possible from those competing interests. So I wish that we could sit here. This guidance is going to be struck down or it's going to be sustained and be the way of the future. There's no way to know. That is being litigated as we speak, today in New York State and in states around the country. So I do think that's a great example, Howard, of how we have to be mindful of just because state ed says something, right? We still have to be mindful that they have A, authority to say it, B, that we're analyzing whether that recommendation is consistent with other obligations of the school district. The other one that we talk about as a practice is that this guidance, raises some concerns that have been expressed under FERPA, because under FERPA, parents control the right to adjust their educational records of their children, not the children themselves. So fascinating issues, none of which we're going to resolve tonight, but all to say, it's definitely rock and a hard place situations for boards that are trying to stay out of legal trouble right now. That's very hard to stay out of legal trouble on these transgender issues, whatever side you take, right, Howard?
Yeah, so one thing that is, when we talk about this particular issue that's troubling is that we know that sometimes transgender students, struggle with the issue of what they're going through. And there have been high rates of suicide involving transgender students. And one concern we've had about withholding information from parents is that it puts the parents in a position where they cannot get help for their child that their child may need. And it seems to operate on an assumption that parents won't be tolerant. And I don't know that that's a fair assumption. And our concern, or at least my concern, would be if this case like this were ever to hit the Supreme Court of the United States, which is extremely conservative right now, they would find that guidance to be problematic. But I think the point of all of this is that when you look at guidance that is this controversial, this unsettled law, that it's not a good thing just to automatically say we're going to follow it, that you need to consult with your own legal counsel about certain aspects of the guidance, whether there are certain unique situations that might guide what you're going to do. And again, that's what your counsel is for, to be on the front end of those questions rather than after the lawsuit comes in. So compliance with guidance can sometimes just be very tricky. Although a court may give deference to the guidance, they're not bound by it. So anyone else want to chime in on that? And any questions from the audience about that piece of it? You want to move on to advocacy?
Sure. And before we go there too, just getting back to the role of the DS, this question has come up in the Q&A chat. Uh, Kind of explain the DS's role as a representative of the Commissioner of Education and therefore carrying out whatever initiatives under the current, climate, carrying out regionalization plans versus their role working for and reporting to the Board of Education of the BOCES, and how there's a distinct difference between the two.
So, so in terms of their role with regionalization has been set by regulation. So that's kind of a structured role, and I also have seen the DS take on other roles. For example, when we've had some test cheating scandals, the DS sometimes have investigated that and been involved in that. But a lot of times that authority will be delegated via regulation by the Board of Regents or the Commissioner.
And then they serve like a dual role too, as acting for the operation of the district and then reporting to that local board, correct?
Yes, they have a lot to say. BOCES has programming that needs to be discussed internally in terms of things. So, and they have their own operations, their own employees, that is very consuming with that. And there's typical governance as there is any other entity with vendor contracts and all of that. So, so Bob, if we can move a few slides to advocacy. Okay, so I finally got an opportunity to use a Ted Lasso quote. I've been waiting forever for that. And I think it's very apropos here. And so yes, the state education department has a lot of power and the commissioner has a lot of power. But that doesn't necessarily mean that we're have no ability to do anything. And so advocacy can take many forms. I think we saw with regionalization, there was such a outcry from school districts that they actually did go ahead and change the regulations. Whether they went far enough, I think that's going to be in the minds of individual schools. But there was at least, you did see some movement from just an outcry of it. School districts can also engage lobbyists, and Kate, there are certain requirements for that. That's my understanding.
Yeah, so there's a distinction. The main point, and we could have a whole presentation just about the rules that are required for being a registered lobbyist. We won't bore you with all of those because chances are if you want to do formal lobbying, you're going to hire a lobbyist formally who's going to be familiar with those rules and appropriately register with the state. But they're in order to be paid to lobby someone in Albany, you have to be registered as a lobbyist. The good news is we've received the question over the years from board members of, as a volunteer, is there anything that prevents me from quote unquote lobbying for various things in Albany? And the answer is no, because you're doing it in a volunteer capacity. As long as you're not receiving compensation to advocate for various things to your state representatives, that would not fall within the formal rules of lobbying, which would apply, for instance, if you hired Howard to go lobby in Albany for you, he would have to be a registered lobbyist. Now, fun fact, we actually do have a few lawyers on our bond team who are registered lobbyists. They're registered in Albany to perform that service. They do all the required annual filings, they pay the fees, they do their disclosures and all of that. So we have that capacity at Bond, but the four of us on this team certainly are not registered lobbyists, so we do not engage in that activity directly. So that's really the formal lobbying, but we really distinguish that formal lobbying from more of the informal lobbying that I think is absolutely within your authority as school board members. We occasionally get the question, is it permissible for school board members to lobby or to engage, expend district funds to advance certain regulatory or legislative initiatives? And there is an old opinion of the comptroller that says it's perfectly permissible as long as there's a bona fide district purpose. And certainly advocating for your district state aid, for benefits for your school district would fall within that capacity. So we've seen this come up in lots of very, I would say, high stakes matters, right, Howard? Like, like our complaint from Middletown involving Foundation Aid and Westbury and Brentwood as well. That was a more high profile sort of matter where we used litigation to try to advance, our initiatives on behalf of our clients. But we've done this more on very mundane issues too. So I'll give you an example. We had a school district in Onondaga County here that, due to a clerical error, had a misfiling of their transportation aid forms. As a result, that is a strict requirement. State Ed says if you do not file those aid requests on time, you are barred from recovering transportation aid on that contract. So they were looking down the barrel of a pretty scary gun. They were looking at essentially having millions of dollars of state aid that they'd anticipated as revenue not coming in because of a simple clerical mistake in the business office. So those board members got on the phone and they got in their cars and they drove to Albany and they pleaded with their local representatives to make this right. And it was corrected. We got special legislation on behalf of that district to correct the oversight in their aid filings so they would not be harmed by that error. So advocacy can be used for some of these very big, high profile issues we're talking about, but it can also be used just to try to get traction on issues that are important for your local districts. Most local representatives also will allocate a portion of their bullet aid, the aid that is within their sole discretion, to assist the school districts if there's specific initiatives that they want to pursue. Howard, do you want to piggyback on that to talk about some of the other advocacy work that is possible for school board members?
I do. So Bob, if you could go to the slide for the William Floyd lawsuit. So, back one. So, I just want to talk briefly about litigation and what litigation can accomplish sometimes. So, ordinarily, when there's an act of the state legislature, a school district does not have legal standing to challenge an act of the legislature, as opposed to a decision of the commissioner or regulation of the commissioner. The reason for that is that the courts have said, well, school district, you're really just a subdivision of New York State, so you can't kind of sue your own parent in a sense. The exception to that would be when the legislature enacts a law that could cause the school district, if it enforces it, to violate the Constitution. So many of you may recall the MTA payroll tax that was enacted by the state legislature. And our friend Bob Vecchio, I remember at a press conference saying that when he was president of the William Floyd School District, that he was not going to allow the MTA to use the school district as an ATM. And we were not going to use school district funds to help fund the MTA. So he asked us if we could bring a lawsuit to challenge this new law. And we turned this over to our tax attorneys to come up with an argument as to why this law was unconstitutional. And then I went into court one day to argue it, and it was quite a very, very convoluted and complicated legal theory. And the judge just put her hand to her head and said, please do not make me have to decide this case. And lo and behold, that part of the law that applied to school districts was repealed. So we never actually had to litigate it to the end. But this was one way of being creative and trying to attack a law that we felt was unconstitutional. Next slide.
And the challenge there was, according to the Constitution, you can't have a intergovernmental entity take out an interest-free or give an interest-free loan to another governmental entity.
Yeah.
And that was the argument. Ironically enough, I will say, sometimes consequences come with actions that you take, even if you're right. A particular state senator was not happy that we did that and gave us a real hard time. I could tell you we got no bullet aid from that state senator until that state senator was no longer a state senator. But surprisingly enough, very quickly after we filed too, Howard, we suddenly were subjected to a special ed order too.
Yeah, I can't. Those were related. but you know.
You always have to keep in mind which bears you're poking when you pursue any form of advocacy as well. That's an important point, Bob.
I'm not implying that they
Yeah.
were connected, but
So-
timing wise was a little suspicious.
So this is also another form of advocacy. Instead of being a litigant yourself, you sign on to a friend of the court brief. And so this way you're not an actual party to the litigation, but you want your voice heard as part, and you can join other districts or other legal entities to sign on and make your arguments heard. So this is one that we did for the Middletown School District. Then the next slide, please. So this was hard to see, but this was quite an unusual filing. We did this initially for Middletown, but then we expanded it to some school districts on Long Island. Candace, which one signed on? This was the OCR complaint.
Yes, this was the OCR complaint. So both the Brentwood School District and the Westbury School Districts were very active with this. And through their efforts, they managed to recruit neighboring school districts on Long Island that our firm doesn't necessarily represent, but they also had been aggrieved in not getting the proper foundation aid funding that they were supposed to receive. This was a very interesting situation. We're talking about not being able to go after the state when you are a subdivision of the state, as any school district is. And I think this was a really creative approach to kind of attack that problem, being that our argument was that New York State was not properly funding school districts, and the way that the funds were being distributed was inequitable. You can't go after New York State for doing something wrong. So what do? You go to the federal level, U.S. Department of Education Office for Civil Rights, and say, hey, federal government, the way that New York State is portioning out foundation aid funding is inequitable, it's discriminatory, and we believe that you, as the Office for Civil Rights, need to intervene to make sure this is corrected. So that is the nature of the complaint that was filed by Middletown, and I'm sure Kate and Howard, you have more to add on this, but I thought it was a really creative and novel approach, and our clients appreciated the fact that we were able to use this as an advocacy tool to protest. There was a large protest. Newsday covered it several times. It got a lot of traction and a lot of exposure, and sometimes that's what you need more than even a change in the law, is just to get the eyes and ears of the decision makers, of the lawmakers, so that they know a school district is not happy about this, and their constituents are going to remember this when it comes time for the budget process and for elections to come around.
Yeah, and that's the big thing, is the political pressure, because you're not just, school district just isn't some faceless entity. It is made up of voters, and that's where you can wield power and pressure. Another form of litigation is what we call an Article 78 proceeding. So let's say we get decision from the Commissioner of Education in an appeal that we just didn't think was right. And what we're seeing now, just as an aside, it used to be in most of my time representing school districts, when we would have appeals of, let's say, student discipline or staff discipline, the commissioner would pretty much give deference to the school district's decision. And although the commissioner can say, can substitute judgment, most of the time the commissioner was saying, I will not substitute my judgment here. The current commissioner is a little bit more inclined to say, no, school district, you were wrong. Your discipline was wrong. Your decision was wrong. And the vehicle for challenging that is filing a proceeding in the state court in Albany. And we have done that, and then an appeal from that goes to the appellate division in Albany. And Kate has been handling a really interesting case where, for the first time ever, the Commissioner of Education held that a probationary teacher had academic freedom, which is, a huge right to give probationary teachers that, in our opinion, undermines our right to terminate a probationer at will. And Kate did a great job arguing that before the third department, and we're waiting on pins and needles for a decision. But I don't know if, Kate, if you want to expound on that a little bit.
Just that, I guess, Howard, you and I have not shied away from suing the commissioner. We think we're probably not her favorite person. There's a lot, I think there's DSs on this call. We should be careful. They may report back on us, but no, we have, and this one out of one of the BOCES is an important case. because like Howard said, it's not just about that case alone, but it's because the rules that the commissioner made in that case are going to have statewide implications. And I think the best proof of that was that the New York State School Boards Association is concerned about that decision as well, and ended up intervening in the case to file a friend of the court brief, an amicus brief on our behalf. But we've done it before as well. We've had rulings that we just think cannot be reconciled with existing law, and those decisions are appealable. Now, like Howard said, there's deference due to the Commissioner of Education in those proceedings when you take an appeal, because she's regarded as the statewide expert in education. So the uphill battle in those cases is that there's case law that says if the commissioner is weighing in on an issue involving educational policy, you're out of luck. We are going to give deference to her opinion. That said, she can't, you can't streamline everything into educational policy. A lot of things are more concrete, black and white rules, applications of regulations and statutes, et cetera. So, again, it's not a slam dunk, certainly, to challenge an administrative agency, but it is an option as well of advocacy where you believe that something's been erroneous. And one of the areas where we've seen advocacy in that area, where I don't believe our firm has personally handled one of these, but others have, is around some of the decisions coming out of the Special Education Quality Assurance Office as well. A lot of those decisions are seeming to take a very kind of expansive view of the regulations that's new compared to what has been rolled out in the past. And districts are not hesitating to file these Article 78 proceedings to challenge those findings when they're clearly contrary as well. So great point, Howard, about Article 78 and litigation as a tool of advocacy.
So a couple of things to consider before you do litigation. One, you need to make sure you have a majority of the board to commence a proceeding, and they have to do it by a public resolution. There was a case that mentioned that. The other thing you have to bear in mind, the cost of what lawyers, although we certainly think they are always worth it, they are expensive, and doing litigation can be expensive. And then one thing, we really need to take a step back from is what is the end game with the litigation? If we're challenging something because there was a procedural glitch and we win, are they just going to fix the procedure? And if we're challenging something because there may be a gap in the law, if we stop and think about it, well, if we win, is the legislature just going to fix the gap in the law? So these are things we need to take a step back before we plow ahead with that. Now, sometimes we may feel that knowing all of those risks and knowing the expense, our constituents really want to make a stand here, and then we're going to do that because we think it's the right thing to do. But those are all factors to consider. And as Bob alluded to earlier, we're somewhat hesitant to make an enemy of those who feed us. But, sometimes we do have to take those stands.
Absolutely. Now for the panel too, and thank you. And I know we're kind of winding down here to the last 17 minutes of the webinar that we've allotted time for. The table of organization that we had up earlier for the State Education Department, this is unelected folks within the bureaucracy of the State Education Department. Does the governor have oversight over SED? And talk to us about the role of the legislature, right? Because my understanding, and I'm not a lawyer, nor do I play one on TV, but these lawyers are very, very good. So where does the governor have oversight over SED, if at all, or the commissioner of education? The Board of Regents, we know, is appointed by the legislature. So are they accountable to the legislature? So give to us the system of checks and balances with the State Education Department with the other side of the street, as they would say.
Okay, so the governor, certainly where we get concerned with the governor is the budget and the presentation of budgets. And is there going to be enough and an allocation? Same with the legislature. What are they going to do with, our funding mechanism? And certainly the legislature has tremendous power over us in terms of enacting laws that we typically cannot challenge unless there's that, rare exception of that. And the commissioner, the governor has appointment authority, as does the legislature. And we can do our lobbying there as who they ought to appoint. Whether they listen, I don't know. I don't know if anyone else wants to chime in on that.
Yeah, I think you're right about that, Howard. And, we find at times that moves made by the commissioner may not be popular, but she's making them under the premise that it's supporting a law that was created by the legislature. So what comes to mind is the mascot issue, right? Many districts were not pleased that they needed to change their mascot. And they said, well, how can the commissioner do this? What is the authority for that? Well, the commissioner based the authority for that in DASA, the Dignity for All Students Act, which was passed by the New York State legislature. So essentially saying, listen, I am just outlawing mascots that have any type of Native American symbolism, because if I don't do that, DASA is not going to be implemented in the manner that the legislature intended. So a lot of this kind of does tie back to the legislature and the laws that were created. That's just one example that comes to mind.
Right. And to segue off of that mascot question, we know there is pending legislation. Do any of us know what the status of that legislation is? Article 78, not legislation. There was a suit filed by some districts. Do we know where the status of that suit is?
I do not.
I don't, but I have not heard word that the rollback of the guidance regarding no more Native American mascots or any of the DASA implications is changing anytime soon. So if districts are kind of holding out for the status of that case in order to decide whether or not to implement those mascot and logo changes by the end of the school year, I don't know that I would be that optimistic about it. I think that in order to comply with the law, if that's their plan, they should continue making moves to change those mascots, because the deadline is going to be approaching at the end of this school year.
Okay. And then again, getting back to clarification, you have a Board of Education for BOCES. The DS is carrying out the initiative, getting back to the regionalization question, and we're not going to weigh in on some of the pending stuff that may be challenged legally, but the distinction between, can a BOCES Board of, I guess, let's put it this way, can a BOCES Board of Education direct the DS not to participate in an initiative that is being directed by the commissioner to the DS?
I would say no. That would be fraught with peril to do that.
Right. So if in this relevant case, somebody says to the BOCES Board of Education, stop the DS from moving forward with the regionalization, they do not have the authority as the local Board of Education for BOCES to override the commissioner's directive to the DS.
So again, so that would be a regulation. So the same rule would apply where we have Education 306, which says you have to comply with rules and regulations. So that would be a very risky proposition to defy that.
Every officer who takes an oath swears and affirms that they will, uphold the laws, constitutions, and constitution regulations of New York State. So there may be lawful ways, as we've discussed, to challenge initiatives that are passed down. But we should clarify as well that, when we say that the DSs are the agents of the commissioner, we do not mean to imply that they are advancing this regionalization agenda. They're simply charged with implementation as the supervisors of the various regional districts, right? They are not they're not spearheading this. And I, if anything we said earlier suggested that, I wanted to make sure that clarification was very clear, Bob.
Right. And to be very clear, again, the DSs wear two hats, right? So they are a representative of the commissioner locally within the region, and then they also report to the local BOCES Board of Education for the operational and the services end. So it's almost like a dual job function.
Mm-hmm.
Right.
Are we understanding that correctly?
Correct.
Yes. And to avoid this position of risking being removed, the thing to do if you felt that strongly that this law was problematic or this regulation, again, is to file your Article 78 proceeding. And as part of that, there's something called a stay, which is akin to an injunction, and asking the court to say you don't have to comply while the litigation is pending, is playing out. But in the absence of getting that stay, I think you are best advised to comply with the law until you get a ruling from a court striking it down.
Very good. And as mentioned several times too, any questions like this that come up, always seek out your board counsel to have them research, weigh in, because as knowledgeable as Bond, Shonik, and King is, and as great of a representative Mr. Miller was for my district for many, many years, there's a lot of talented firms out there that specialize in education law and are there to represent you, the boards of education, because they work for the boards of education. That's another thing, right? Let's talk about the lawyer's role within the district. Sometimes if you're a new board member, you may not understand that the board appoints the general counsel and reports to the board, not the superintendent or the business official. You work directly for the Board of Education.
Correct. And we are there to help the Board of Education carry out its mission. And we have to be mindful that we are not de facto members of the board. So we give advice to the board and counsel to the board and guide them as best we can. But at the end of the day, we are not board members.
So here's another question that came up when the Nassau County judge ruled that the mask mandate was enacted unconstitutionally. There was a 2-day lapse in the mandate. At this time, the SED issued guidance to continue with masks. Was this correct? And did schools have to follow that guidance on a constitutional basis? That's a pretty heady question. So,
yeah, and my answer to that is check, please. But actually, so our guidance, our advice at the time, and my colleagues will correct me if I'm wrong, was to still comply because we felt that decision was going to be annulled by the appellate division. Plus, we thought the state has the benefit of something called an automatic stay. So we said still comply during that period.
But it is important, Bob. I think this question is really a good one because it also illustrates the point of this is why it's important to get your counsel involved because these decisions are very procedurally complex, right? We need to look at if there was an injunction issued, who is it binding against and what is the jurisdiction of the court that issued it? So in that particular case, and I don't remember the decision in great detail, but my recollection about that masking decision was that it was only applicable to certain counties that were within the jurisdiction of that Supreme Court judge that issued the decision. That said, state Supreme Court judges, they are courts of general jurisdiction, which means they can issue statewide injunctions. They have that authority. And sometimes they do. And we've seen this issue with the Title IX regulations. It's been extraordinarily hard to follow because the Moms for Liberty group has obtained an injunction of the Title IX regulations, but the list of entities that injunction is applicable to keeps changing. So this is one of those areas where, again, you'd want to consult with your legal counsel about your obligations to comply when litigation's ongoing, because it will depend on what is the court that issued the decision, what was their authority, how much jurisdiction do they have, do they govern your particular school district, and what was the wording in the injunction? Is it an injunction of statewide applicability versus simply applicable to certain entities that were present before the court? There's a lot of considerations that go into that.
Yeah, and our concern also was during that short gap is that if we took the position, okay, we're going to follow what that judge did, and then a few days later it was vacated, it'd be kind of confusing for the kids to put the mask on one day, take it off, put it back on. So those were some practical considerations about that, but we felt that the injunction was going to be vacated.
Okay, so again, turn to the advice of counsel because they have a lot of moving parts that they consider that as a board member, I wouldn't even known about half the stuff that Kate just said. So.
Yeah. Just again, this goes back to your own lawyers for your own districts may have very different takes on some of the things that we've said. So you should consult with them. And again, as when all of the things with COVID were going on, we were typically in contact with our colleagues at other school law firms with whom we really try to work collegially to make sure that we were all on the same page with a lot of what we were saying. Because a lot of it was confusing. Things would come down one day, early in the morning one day, it was hard, but we really tried to be consistent among the school law firms.
Yeah, very confusing times for sure. And then just getting back to make sure we're clear about, when a commissioner issues a regulation, it is normally tied back to, or not normally, it's tied back to something that's been codified in law that the legislature has approved and the governor has signed off on. So the commissioner cannot just put pen to paper and just produce something out of thin air that is not tied back to something that the legislature has given to, guardrails to what they should be doing in their role as commissioner of education.
The commissioner typically should be promulgating regulations that are more detailed than statute. But the commissioner is not, in a sense, is not an elected legislator. If that
Right.
makes
So just like board members, we enact policy, which is general,
sense.
and then the superintendent will enact the administrative regulations to adhere to the policy.
Yes. Now that being said, there is a pretty broad grant of power to the commissioner to oversee the system. So, we'd have to look at particular regulations to decide whether, did this really exceed the power of the commissioner to do?
Okay. So in our last couple of minutes here, just an observation, because you've been at this for a few years. This is not your first rodeo. This commissioner compared to others, what do you see different in the way she goes about business of either appeals or decisions, compared to Commissioner Elia or Commissioner King? What do you see different in this current administration compared to what you've seen in the past?
So my sense on that, I alluded to it earlier, was a lot more of a willingness to say a school district got it wrong when it comes to like student discipline, teacher discipline, what's a counseling memo, things like that. And then we've seen from the state review officer some decisions that the tone was surprising. And again, not taking a side here on regionalization, there was a letter that was sent from the state back to one of the council involved in the potential Article 78. The tone was a lot more aggressive than we've seen in the past. So my sense is that the current commissioner is more zealous, I would say.
Okay.
I don't know if my colleagues disagree with that, but that's my sense just reading the decisions.
Yeah, I think there's truth to that, Howard. I guess what I would add is that in addition to seeing decisions from the commissioner's office, which we have always seen when people file appeals regarding student discipline or residency or any of the broad range of issues that people may appeal to the commissioner about, we're also seeing more opinions of counsel in which the commissioner's office is proactively telling us this is the roadmap to how we're thinking and how we plan to rule in the future. So it's almost like a heads up. This is how we may rule on your case if you're thinking about going down this road. So we are seeing more of that, for better or worse. I know people have mixed opinions about that, but I do think that's a distinguishing factor that we're seeing with this current commissioner.
Okay. Any final thoughts from our panelists before we close out the evening?
No. I mean, it is supposed to be the holiday season of, everyone goodwill and all of that. But we are seeing some really difficult things playing out in the schools. And some where there's not off-the-shelf answers to things. And again, our advice would be to make sure you're using counsel proactively rather than wait until there's a legal challenge to whatever was done. And I have to say, I've seen things lately with behaviors from students and staff and from parents that I've not seen before in my career, which is saying a lot, because every day I think I do say, well, now I've seen everything. Of course, the next day something new drops. So I think it is difficult times, but I think, we are seeing school districts rise to the occasion, be creative, be proactive, and your lawyers are supposed to support you in those efforts.
All right. Well, with that said, first off, I want to thank our panelists for their expertise, their input, their opinion, and educating us. I know, listen, I've been at this game for over 2 decades with Howard, and I learned a thing or two tonight too. So we appreciate you taking the time out for putting this material together. Again, this recording will be available along with the slide deck so that if you miss something or you want to re-review something, it's there. Any follow-up questions that you have as a result of this webinar, I think Howard said it perfectly. Follow up with your own counsel. Of course, if you try to reach out to Bond, Shonik, and King, Howard is at the local office here in Garden City. I'd be happy to take your call and email, of course. And on behalf of the Nassau-Suffolk School Board Association, we want to wish all of you a very healthy, happy holiday season. Thank you for what you do for advocating for children and delivering high-quality public education to our students day in and day out. And we appreciate your support here as an association and an organization. And until our next event, which will be in January, the joint conference, where we'll be focused on a lot of advocacy issues and some of the lobbying efforts that will be underway in the coming year. We thank you for tuning in tonight, and we will talk to you soon. Have a good night, everybody. Thank you.